Okay, so today we're going to do the outline for property, but my caveat is I'm going to see if I can get to from sale of land to the end of the course, but it's super thick outline, so maybe it's less dense than I believe, and I can get it done. Otherwise, I'll tell you when I'm going to stop. So there is when you're selling real property, there is a pre-contract phase, an executory period, and a post-closing phase. So in the pre-contract phase, people are making the decision to sell, listing with a broker, doing marketing efforts, and negotiating a contract for the sale. And then once the contract is signed, once there's a buyer and a seller, then that is the beginning of the executory period, and that is when equitable title passes to the one who signed to the buyer signing the contract, although legal title stays with the seller. And then that ushers in the executory period, so that's the mortgage and loan app is happening. There's an appraisal and a credit check. There's the title examination to make sure the title is marketable. There's a physical inspection of the property and a survey. And there's document prep, and that is when any disclosures that need to happen. That is when any encumbrances or anything that makes the title unmarketable needs to get fixed, because once the deed is delivered, the doctrine of merger happens, and they cannot get out of the sale. So when the deed is delivered, the money is paid, and then we're closed. And then there's post-closing, where you record the deed and the mortgage, and then title insurance is issued, and if you need, the mortgage can be sold on the secondary market. Okay, so that's the overview. A contract for the sale of land. Generally, you will get a broker. The seller will get a broker, and there's 3 different type of brokering styles. Well, 4. You can do a piecemeal one in some places, but normally the options are open, and that means the broker will get a commission if they effect the sale, but the owner could use multiple brokers or sell themselves. So the broker's only gets commission if it's theirs. That one's kind of rare. Then there's the exclusive agency listing, and that authorizes one broker but allows the owner to sell. And there's generally a set period of time. So if the owner sells on their own, then the broker doesn't get a commission. And then the third one is the most often used, and that's the exclusive right to sell. And there is a contract period between the seller and one broker, and that broker gets the commission during that time period, no matter who sells it. So the biggest goal of the broker is to get the deal to close. Conflicts arise when commission is paid by the seller, but the relationship is with the buyer. And really, to get around those conflicts, you just need disclose. But disclosures are not a warranty. So listing contracts, they usually include the property listed, the length of the listing. So this is between the seller and the broker, and it will include property listed, the length of listing, usually 3 to 6 months, price to include, and like what fixtures are included. At my house, everything was included except the built-in microwave, and it was like a really weird size, and I had to do like patchwork to get another one to fit. It was not cool. Leave the damn microwave. Anyway, it also will say if the seller is going to allow a lockbox so that the broker can show the property and get in. It will define with a period to pay the commission and the duties and responsibilities of the seller's agent, because usually there's 2 and then they've got to work together. A commission. The commission is what is paid at the end to the brokers for their work. The Ellsworth-Dobbs rule, Ellsworth-Dobbs, says, barring default by the property, no commission is deemed earned until the deed is recorded. That is the first time that I've seen that I've understood recorded. So I'm going to ask that question, and you might see a updated video. The agent may have the right to share with seller the deposit if the buyer breaches. So if the buyer breaches, they might be able to still get something. Where jurisdictions do not recognize the Ellsworth-Dobbs, they find no contractual provision conditioning brokers' commissions on buyers' performance. Where jurisdictions do not recognize Ellsworth-Dobbs, they find no contractual provision conditioning brokers' commissions on buyers' performance. Generally, commission is paid when from the proceeds at closing, and if purchase price is paid in installments, a commission can be similarly set up or not. Written contract or writing required. So for the sale of land, there needs to be a writing, and the kind of writing is a negotiation. The writing will exert more pressure on parties to complete the transaction. It's prepared by brokers who wish to ensure payment of sales commission, and the enforcement will require writing unless it is taken out of statute of frauds by exception, and we'll talk about those exceptions later in the process. So the writing needs to include some essential terms. One is the price. Most states require the price. And if it doesn't explain how it's going to be paid, the assumption is cash. ULTA permits open price contracts, and installment payments, if they're going to do that, require details in the deed. And then the essential terms will include conditions that the buyer is discharged from the deal. And usually that is things like the title needs to be marketable. If it's unmarketable, they get out. So I'm going to use all of they will get out of the deal if they are unable to obtain a mortgage loan, the buyer is not accepting physical conditions based on the disclosures and inspections, loss or damage during the executory period, that needs to be upfront because otherwise we'll talk about how that works out later. And financing, if they can't get financing the way they need, if it's not reasonable, all of those things. Title encumbrances, buyer will accept. So title is not marketable with encumbrances, but a buyer can waive that unmarketability and take title. And most of the time people do because there are existing street or utility easements. There is current property tax because they're paid at the end of the year. There's special assessments from the HOA, or there's zoning ordinances and codes. The zoning ordinance and codes don't make the property unmarketable, but if there's a violation of a code, that makes the title unmarketable. So that's different, and that needs to be figured out. The preliminary title report, marketable records, that is also one of the essential things that will be in the contract. And it'll say that there will be, you'll see what the marketable record title is. Question. And a marketable record title is everything on the title is documented. So that's really what you want. You want a marketable record title. But if there's adverse possession and they went for a quiet title to be obtained, then that will be on the marketable record title, but otherwise it will not be. Other terms on this, the essential terms are the parties, the land description, and when the closing time will be. The closing time needs to be reasonable. We'll talk about that in a minute. But the key term here is time is of the essence. So if it says time is of the essence, that means that the time they put on the contract, time is of the essence, 3 o'clock, December 1st. That means at 3 o'clock on December 1st, if the contract has not been tendered, so the property and the money have not come together by 3 o'clock on December 1st, time is of the essence, that means the contract's finished. It's done. It didn't happen. If it doesn't say that, then we're just looking at reasonable. But if time is of the essence, it's to the second. Either happens or it doesn't. If a contract did not say time is of the essence, but then the parties want to put it in, they may. We'll talk about that in a second. But only one party has to say time is of the essence. It doesn't need to be a meeting of the minds when they're building this contract. Although that's what a contract is. It's a meeting of the minds. So if one had a problem with that, then they could say, like, no, that's not okay. And so it is a negotiation. Anyway, so the time has to be reasonable. If there is a delay when time is of the essence, even slight is a material breach. So it's done, which discharges the innocent party. There's no duty to have good faith to extend the time. That's not a thing. You can. The innocent party can, but it's not a thing. They can't force anyone. So when time is not of the essence, if a party is late, it is not a total breach, and it does not discharge the other party unless unreasonably late. So if I said December 1st, 3 o'clock, but I do not say time is of the essence, you can't hold me to that time, and it doesn't breach the contract. But if time is of the essence, the contract is breached, and the innocent party gets to decide what's going to happen. Here it is. The late party, okay, so if the time is not, if it doesn't say that, if it just says December 1st, 3 o'clock, the late party can still enforce the contract by a specific performance or get restitution of down payment if the other party refuses to perform, because the innocent party doesn't have that option if time is not of the essence. That said, the interim party may be liable for interim delay damages, and the party who is late cannot recover damages if the other party refuses to perform. Okay. Reasonable time, I need to ask about that because that doesn't, okay. Reasonable time to close. A reasonable time to close is based, they look at reasonable. So reasonable is about the type of the contract, the conduct of the parties, the presence of or absence of good faith, the experience of the parties, possibility of hardship or prejudice to either party, specific number of days provided. So we saw cases where the people had already moved in, they were waiting for the sellers to close, but the sellers were getting rent, and so they just didn't. And so obviously when you look at the experience of the parties and the conduct of the party and the absence of good faith, the court very easily said, like, no, you're just stalling because you're making more money getting rent, and that's not, they have a contract, blah blah blah. Anyway, there you go. And then when tender happens, and tender is just the time that the money and the deed meet. And then you're going to have written in there what the seller disclosures are. So the seller has to tell us about all material breaches. We're going to talk about that later. And what the earnest money is going to be. And the earnest money is like the down payment. And in the Northeast, this is typically 10%. In California, it's not more than 3%. And sometimes in like plats or subdivisions, it can be as little as $100. So, and then it's also in the contract of whether it can be kept at breach. If it's substantially higher, like if it's 10%, probably not. 3%, probably. If it seems punitive, that's not going to fly because the court doesn't like that. All right, then we have oral contracts or oral modifications. Within the statute of frauds, they must be supported by a writing. So real property has to be sold with a written deed, but modifications can happen. So within the statute of frauds, but they must be supported. So if not in writing, it is ignored, and original contract is unchanged unless for part performance, and we'll talk about that in a second. If it's a rescission, it doesn't need to be in writing. Oral modifications or waivers of time of performance are often upheld. Admission can substitute for a writing in some jurisdictions. So in one case, there was a lot of people who had heard, and so they let that happen. Modifications supported by writing, so oral contracts can be substantiated by part performance. Allows for enforcement with no writing so long as there is a contract or some form of meeting of the minds, which the court apparently doesn't like that term anymore. But part performance, you must show at least two. So it means you have possession, you've made part payment, or you're making substantial improvements. So one of those, you need two of the three. Three is the best, but you need at least two. Possession, part payment, making substantial improvements. Theories on part performance. So reliance or estoppel is the restatement. If a party seeking enforcement is reasonable enforcement and reasonable reliance on contract has changed position, that injustice can be avoided only by specific enforcement. So if the party started the improvements and took possession or paid with the reliance that this was going to happen, then that shows that there had been a writing or a contract or a meeting of the minds. And then it's mainly partially just evidence of there being a contract. Purchasers act as a part performance treated as unequivocal, referable to agreement. That makes no sense. I'm gonna ask Professor Saxer. Seller can rely on purchasers' acts to prove contract. And that's pretty much, they're looking at what they're doing and saying, would a reasonable person have done this if there hadn't been a contract or if there hadn't been a agreement? Title to be conveyed, implied covenant of marketability. Checking title. Title must be sellable. That's what marketable means. So written attorney opinion. So how do you check? So in the South and the Atlantic, usually an attorney writes an opinion based on personal search of public records. I would not want that job. The Midwest and the West, they use a more is called an abstract, and it's a copy or summary of instruments filed in the courthouse but prepared and sold by a private abstract company. That seems nicer. And then in the West and large cities, you'll have a title report. And by a title insurance company, they own their own internal records called a title plant. Report indemnifies for any defect not found in the report. So I like that much better, right? And so if there are any encumbrances on the title, the buyer must explicitly accept to make the title marketable. But if they don't talk about it, it's merger. And the merger doctrine says buyer must examine title before closing and give seller opportunity to cure. Actually, we're going to talk about that in a second because we're going to go a little bit more into marketability because you need to know this, you need to know this, you need to know this. Marketable is buyer should bring title search down to date. So if you did one in a preliminary search, it should be done again the day of closing to make sure that nothing has recorded in your executory period that you didn't know about. So is it free of encumbrances, leases, covenants, mortgages, easements, liens? Beware of taking subject to easements of record, because usually it will say that, and if you don't explicitly say otherwise, those are there. Actually, the seller has to cure. Otherwise you can't buy it. So it's kind of like, okay, well, you can take it with them, or you can try to have them cure it. If they can't, then you've got a decision to make. So visible or beneficial encumbrances are okay. So if you see a power line going across your property, like that's an encumbrance, but you can see that, so it's not like you already know. You can see if there's lack of access to a public road, if there's any encroachments. We're going to ask you exactly what that means. If there is an adverse possessor, please say you went to the property and that you did not see anyone continuous, open, actual, notorious, hostile, doing anything as that of a true owner, because that's going to be your problem if you buy that property. Tolling, babe. Ordinance violations, but not the ordinance itself. So if they have a violation, that will be on the title, and you need to know about it. And that would make it unmarketable, the violation, not the ordinance. Restricted covenant violations, and even the covenant itself, because that's an encumbrance. The physical condition has nothing to do with the title. So apparently something about toxic waste. We didn't even read that case, so I don't really know. I shouldn't have said that. Anyway, going on. Not subject. Okay, so pretty much marketability is you are not going to be subject to unreasonable litigation just by purchasing property. And then public restrictions do not cause title to be unmarketable, so that's more like zoning. All right, then we're now gonna go back to the merger doctrine. So the buyer must examine title before closing and give the seller the opportunity to cure. The title must be marketable at closing. So a lot of times there's a mortgage. The title is, the title is subject to a mortgage of the seller, and there is a mortgage due or payment due payment due on closing or sale, and that means it'll be taken care of as soon as your sale goes through. So that's common, and that's allowed. Merger doctrine, I have written again. Contract, title, covenants merge with the deed. This is modernly disfavored, but it depends on what type of deed is delivered. So that means if there is encumbrances that you have not directed to be fixed and you go ahead and close, they are yours. They are not something that you can remedy after the fact. They are yours, free and clear. It depends a little bit about what kind of deed you have. But once it becomes a deed, then you can only sue on the covenants, the deed covenants, which we'll talk about later. I feel like I say that over and over. So there can be a defects in the title, and we're going to talk about those. So defects in record chain. So A to B to C to D to me. But if C is not recorded, then there will be a hole in the chain. So then I would say, okay, I'm going to go look back at D, and then I'm going to go see who gave it to D, and I'll see that C did. But because C didn't record when B gave it to them, we won't have any record of B to A. We won't have any record past C in that chain. So we have a defect in the chain. There could there could be private encumbrances if you didn't look to see if they're recorded. There has to be an express waiver to get them off. Then also zoning violations. Why did I have this twice? I'm confused. I mean, we already just said those make it unmarketable. And if you take title and they're on there, then you have to take care of them. I don't know. Okay, we're gonna clean that up a bit later. Defects in the premises. Caveat emptor. Buyer beware. Caveat emptor, buyer beware. The principle that the buyer alone is responsible for checking the quality and suitability of goods before a purchase is made. That is caveat emptor. Apparently there are exceptions. I don't know what they are. I'm gonna ask. That may have been from looking somewhere else. I don't think we talked about it in class. Duty to disclose. Duty to disclose material facts. This is the Easton Rule for California Civil Code. It is an affirmative duty in California to inspect and disclose. This duty is limited to 1 to 4 unit family dwellings. So this is the seller's duty to disclose. They have to, could be the broker. We're going to ask. reasonably competent and diligent visual inspection and disclosure of all facts materially affecting value and desirability of property. So if it's a material defect, it has to be told. If it's not in an accessible area, then it could not be known. Disclosures of physical condition, financial issues, as well as restrictive covenants may be homeowners association rules. So those things you might say are inaccessible and can't be known, but you have a duty. Those are material. And it's a reasonable, prudent care weighed against the licensee's knowledge of what they do know. Misfeasance. You did something you weren't supposed to do. You can be liable for misfeasance. For nonfeasance, you didn't do something, and you are not liable for nonfeasance. Although not disclosing something you should have is doing something. It's keeping it. So those aren't great words. Anyway, modernly, and this is the majority, requires disclosures of facts materially affecting value of property not visible or known to buyer. So that's like the black letter rule. But the minority is caveat emptor, buyer beware. Implied warranty of workmanlike construction. Builder, vendor, not only liable to client, but also could be to the next owner. Remedies for breach of contract. The defendant must have signed something. It doesn't have to be a contract. It could be a letter, a check, several writings tied together. But the person who is suing better have something concrete from the person they are suing, showing that they were part of this agreement. And then, so remedies for the buyer. So the seller says, I'm not selling it to you. The buyer has a remedy of rescinding the contract, which is rescission, specific performance. So that is making them to do something, and there could be an abatement of price. If specific performance cannot be done, then they could get damages because that is an inadequate remedy at law. I talk about somewhere else why that would happen, but like if you were trying to buy a property and they already sold it to someone else, then they're not going to kick the other people out, so you could get damages. Damages, most of the times are loss of bargage damages. So this is the difference between contract price and market value at date of breach. When seller breaches and property value is lower than the contract price, no damages for the buyer. So if the seller loses money because of what they did, they're not going to owe to the buyer. But if the seller sells to someone else and they make money, the buyer is going to get some damages. Remedies of the seller: rescission. They can also rescind the contract. So this is if the buyer backs out. Specific performance, generally yes. But if it can't be done, sometimes this does my head in, sometimes I get them mixed up. Okay, so remedies, but we just talked about remedies to the buyer. So the seller did something they shouldn't have. And these two areas should have been up here because I already talked about them. Anyway, okay, remedies of the seller. So the seller, their buyer backed out. And they can also do specific performance. If liquidated damages were written into the remedies, like say they got to keep their earnest money, then they're not going to be able to do both. Sometimes the contract will say you get to decide. But if they just keep the earnest money and say nothing, they can't come back later and say, well, we want specific. Well, they might if it's a reasonable time, but like years later, they can't say, no, 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 we want specific performance. That's not gonna fly. So liquidated damages, they may be retaining earnest money, and this could be anywhere from $50 to 10%. California doesn't allow over 3%. So 3% is what California allows. And the contract needs to say that. Expected damages will be uncertain or difficult to prove looking forward. Parties should have in their contract whether they intend to liquidate damages. Amount to be forfeited, again, the liquidated damages need to be reasonable. If they're not, the court's not going to allow it. Courts are split when there is no actual damage. So the property sells for more, so even though the buyer backed out, the seller actually made a profit anyway. And so they have the courts are split there, or when liquidated damages greatly exceed what the damages really could be. So the court asks itself, does the clause act like a penalty? Courts are more apt to strike it down if it appears to be a penalty. Is it reasonable is sometimes measured at contract and sometimes at breach. So when the contract was made, did that money make sense? Or when the breach was made, did that money make sense if there was a big difference between the market value of that? Loss of bargain damages, difference between contract price and market value at date of breach. When buyer breaches and the property value is higher than the contract price, no damage for the seller. We've said that over and over. Why am I repeating myself? Anyway, equitable conversion. I really like this concept. Equity regards as done that which ought to be done. Equity regards as done that which ought to be done. So the statement of this doctrine happens at contract. Contracts regard as done what ought to be done. Why do I keep repeating that's why this is so long, because I keep saying things over and over. This requires a specifically enforceable contract. No special performance if title is unmarketable. Not enforceable. This is not enforceable without a sufficient writing. At time of title, buyer gets. At time of contract, buyer gets equitable title, and seller only retains legal title. For seller, this means for the seller, this was their real property, but now holding only legal title, this is personal property. So if they were to die in this executory period where they have given over their real property and they only retain personal property, we treat the deal as if it were done. So for the seller, this is the doctrine of exoneration. A person who inherits personal property from the seller will get the purchase price at closing. A person who inherits real property from the seller does not get this property or the money from it because it is already personal property. The buyer, if the buyer dies during this executory period, the person who inherits the real property from the buyer will get the property that is bought. And the person, this really stinks. The person who inherits personal property from the buyer must pay out of the inheritance, even if they are not the ones who get the property. I can see some siblings being really mad. Anyway, risk of loss. So this is if something happens to the property during the executory period. The majority, the buyer has the risk and the risk of the loss. But this can be fixed through insurance. The minority, the seller, has risk of loss, and I don't think either. But we really do look at the options. So who has insurance? Who has the insurance is what's looked at, and usually I think there's more into this than I need to look up. But with this, there is usually more, if the buyer has the insurance but the seller's getting paid, the buyer's insurance will hold it in trust for the seller. And so it's a little more of a balancing. But in the majority, the buyer will be required to complete the sale, even if it is a total loss. And that might be true in the minority too. We're going to talk about that one more time. Closing. Tendering is money for the deed. Easy. It can be excused if there is an anticipatory repudiated contract. There is obstruction in closing if neither party tenders at closing or when time is not of the essence and someone doesn't move forward, it doesn't breach the contract. Then there is the recording of the deed, which we go over at some point, probably not in this video. The legal title then passes to the buyer. I'm going to stop that here because this is a long video, and that is just on the sale of land, but the next video is going to be on deeds. So, thank you very much.